My name is Denton Marsh. I have been a court-appointed mediator and civil procedure consultant for 19 years, and I want to tell you about the Wexler employment case. Not the hearing itself, but what happened 14 months after it concluded. The case reached me in the way that some cases do, as a referral from a colleague who had observed the proceeding and believed the outcome deserved a second look. I will describe it precisely. Terrence Okafor was a logistics coordinator at Wexler Distribution for 11 years. He was terminated in March of the year. In question 2 weeks after he had formally raised a concern with his direct supervisor in the operations manager about what he characterized as a systematic discrepancy in shift assignment practices, specifically that overtime shifts had been assigned in a pattern he documented over 14 months, and that the documented pattern showed a consistent disparity along racial lines. His termination was framed as a performance-based reduction in force. The initial administrative hearing concluded without a finding in Terrence's favor. The hearing officer found that the documentation of shift assignments was internally consistent with Wexler's stated scheduling policy. Terrence was not represented by counsel at the administrative level. The decision was appealed. The appeal was denied. The case appeared closed. 14 months after the administrative ruling, a woman named Claudette Ferris contacted the Regional Labor Enforcement Office. She had been a shift scheduling coordinator at Wexler for 7 years and had left the company 4 months after Terrence's termination. She provided a sworn statement. She stated that the scheduling software used by Wexler automatically generated the shift assignments in question. She stated that the algorithm's weighting criteria had been modified in a document she had personally been asked to archive. She stated that she had been present in a meeting where the modification was discussed, that she had understood the modification's likely effect, and that she had not come forward during the administrative proceeding because she had not yet left the company at the time of the hearing and had been told by her direct supervisor that the matter was resolved. She attached the archived document to her statement. The document was a weighted criteria modification to the scheduling algorithm, dated 11 months before Terrence's formal complaint, signed by the operations manager. The Labor Enforcement Office referred the matter to the Circuit Court. Judge Desmond Fairfax, who had not presided over the original administrative proceeding, received the case on referral review. He found sufficient grounds for a new evidentiary proceeding. The new proceeding was conducted over 3 days in October. At the conclusion of that proceeding, Judge Fairfax issued a ruling of unlawful termination based on retaliatory discharge following a protected workplace complaint. He ordered reinstatement with full back pay for the 26 months between termination and ruling, and he directed the operations manager to appear before the County Labor Enforcement Commission. He also noted in the written ruling, and this is the part that I want you to understand, that the outcome of the original administrative hearing had been procedurally correct given the evidence available at that time. The system had not failed. A witness had delayed her testimony for 14 months. The difference between those two things matters. Claudette Ferris testified that she had waited until she was no longer employed at the company because she had been afraid of the professional and personal consequences. She said in her statement, "I knew what I had. I should have come forward earlier. I am sorry that I did not." Terrence Okafor did not return to Wexler. He accepted a position with the County Transit Authority. He filed a separate civil action regarding the algorithm modification. That case is ongoing. I want to tell you what I observed in this case as a professional who reviews civil and administrative proceedings. I observed a man who documented a problem over 14 months with no guarantee anyone would act on it. I observed a witness who held a document for 14 months after the hearing ended before she came forward. I observed a court that, when the full evidence was presented, applied the law correctly and recorded the outcome in writing. The original proceeding was not a failure. The delayed witness was the variable. I want to say both of those things clearly. In 19 years, I have seen cases where the system fails. I have also seen cases where the system works correctly on incomplete information and then works again when the complete information arrives. This is an example of the second kind. The document was in an archive. The witness waited 14 months. When she came forward, the law moved.